Welcome back to the e-learning platform of the University of Teramo. We are here to discuss again the sources of law and legal formats. Gustavo will now show us one of the drawings I made in an earlier PIL lecture. Please, Gustavo, go with drawing number 1. And we will see, some of you may recall that I prepared this funny drawing to show how the law might be considered similar to the water springing out of a source and being delivered to the end users in a jurisdiction, in a city, through a complex system, which is a human structure designed to deliver the water to individuals needing it. So we already know that the water is springing from its official source, like the water source in Mount Gran Sasso nearby here, and is being delivered through a legal system. This system is a non-perfect system, of course. It might not be able to reach some areas within the jurisdiction, so you will see some of the areas marked with a question mark in the drawing. There could be disruptions, so the system might not be able to deliver the law or the water in a specific area for some technical failure, in a permanent way or in a temporary way. There could be introductions of elements from different sources becoming mixed with the official water in the system through creeks, through breaks in the pipe system, through the presence and work of specific individuals or groups having the ability of intervene at key junctions of the system to introduce their own visions about the law, rules, and doctrines. Could be judges, could be politicians reforming the laws, could be economic groups or powerful economic individuals affecting the economy and the society, and ultimately also affecting the law. At the same time, the water system of a large jurisdiction may include water coming into the picture from other sources. We can see the picture, and there is water being imported from distant places, from other official sources, through commercial ways. We see a water truck driving towards the city here, bringing water from a different source, probably to cater for additional needs of the city, to bring the water in blank areas not covered by the official system, or to bring other water in competition with the water from the main system. There could be local customary wells where water springs out and is used at local level by the small communities living near those sources. And of course, there can also be imports at a higher level from individuals probably living in the high-rise apartments in the skyscrapers in the beginning, those with a global exposure, with connections outside the jurisdiction, importing bottled water, for instance. And over time, the availability of water coming from a different place in bottles is more and more available to everyone in the jurisdiction. So you also have the option of drinking bottled water along with the original official options of drinking the tap water from your own water system. This reality can be reproduced for the different cities needing water around the mountain range. So you might have that the same spring, the same source of law. Imagine the Code of Napoleon is brought to different cities through different water systems. You may have other sources as well in mountains nearby, and you might have distant mountain ranges with entirely different water of a different type being delivered to other cities. And then, of course, you may also have institutional connections, structured connections between or amongst several systems deciding to share some of the elements of their water system. And so eventually also the product they deliver to the end users is to some extent similar or characterized by similar features. Imagine several jurisdictions pooling resources together to produce a super jurisdiction, producing rules for all of them, like the European Union, for instance. So this picture is trying to describe this complexity. In comparative law, we may have different approaches, thus studying the law and its sources. The source system is whatever list of official sources is present in every legal system, in each legal system we want to study. It has to do with what we often call the law in the books. The law for the end users, the outcomes of the legal system at the end of the delivery system is what we often refer to as the law in action. The entire picture made of the source plus the system plus the external sources of water can be sometimes characterized as an environment of legal pluralism. Legal pluralism meaning that in the same environment, water from several different sources is available, and this water is used by end users according to the different needs, sometimes according to their available options, or sometimes according to a selection made by the end users to choose this or that water according to what they think is best providing an answer to their actual needs in that particular moment. So if you have available several different legal systems in your environment, like your official legal system, some customary rules, or some other religious rules, all validly present in your environment, you might decide to make recourse to this or that legal system to solve your particular need of that moment. In this case, we analyze this complex situation using this pluralism approach. It's rather that there is more systems at once available rather than thinking that the official system is not working well. When you have funny or outcomes, or you have different outcomes in different places of the same jurisdiction, legal pluralism explains that this happens because there are several legal systems working at the same time, while the official orthodox doctrine of the main official system would just consider that the legal system for some reason is not working properly. A final approach, a more radical approach to legal pluralism could be described by the second picture. Gustavo will now show us the second picture, and this is the way each end user sees the law from his or her own point of view. You see the sources in a very distant place and the system and the city in a closer place to your household, but what you really see is your tap and the water you drink. This means that the law might have a different flavor and a different substance for each individual using it, in a sense. This theory, which is might be called radical or critical pluralism, has been advocated especially by a famous Canadian scholar, Roderick MacDonald, has the capacity to explain why the same law can be applied, enforced, and produce different outcomes at each individual use. In each individual contract, for instance, the parties may use the same sources, the same rules, to produce their own individual final set of rules regulating their own common venture, whatever it is. In a sense, it's what the French say, the Code Napoleon says when they say the law. The contract is law between the parties. This is also another way to see this principle. Is law because every end user introduces some of her or his personal vision into the law she or he is using. So this is a more complex, more sophisticated way to see legal complexity. Every difference at law, every change at law can be considered as the result of a very complex interaction amongst a number of societal forces producing legal norms. We will need to use those sophisticated tools of analysis through the course. I hope you will enjoy what comes next. See you soon. Bye-bye. Thank you. Ciao.